Okay, so I'm here to talk about privacy and security. I talk really, really fast, so I apologize if you miss anything. So the big bad secret is there aren't any really special rules for telehealth in regard to HIPAA. You got to follow the same rules that you do when you see the person in person. However, there are a few things that maybe you want to worry about a little more. And the first of these that I think about are the business associates. So the reason I talk about this first is I often think of them as the biggest area of vulnerability to your PHI. So say you have your cloud storage vendor doesn't configure the server correctly, and now you get a breach of your PHI. That breach, even though caused by somebody else, your vendor, is your problem. And if there's enough people involved, the OCR is going to come knocking at your door, and maybe those people are going to come knocking at your door. So you really need to care about what your business associates do. In addition to that, under the HITECH Act, business associates are now liable to the OCR. So they care. They used to be just subject to contract liability, but now they're directly liable and can be penalized millions of dollars just like you can. So as a result, business associate agreements are way more negotiated than they used to be. In the early 2000s, when we had to sign business associates, everybody just signed them. I don't even know if they read them. Now everybody, you included, should care about what your business associate agreements say. And as I said, because those business associates are such a vulnerability, you want them to assume some additional liability for the things that they do and in protecting your information. So you want to talk about things like indemnification, return of PHI upon termination. Does that vendor hold the only copy of PHI that you have? If so, you better make sure they have to return it to you at the end of things, because HIPAA's a little ambiguous about there. There's loopholes, so you better make sure they have to return it. The cost of a breach, who's going to pay for it if notifications have to be sent out? What about credit monitoring? What about that OCR investigation, hiring a forensic person to come in and see what happened? All those costs, and much less the lawyers. They are the biggest cost of all. So you want to think about that in advance. Who's going to pay if there is a breach? And finally, you have to think about, well, to hell with the breach, paying for the breach. I don't want that breach to happen at all. So you might want to say, what security requirements do you have in place? Know that in advance so that you can protect yourself against the breach. So those are some of the things you should be thinking about in your business associate agreements, not just signing them on the dotted line because you've always done so. So here, the other thing is that people sometimes forget to get business associates and agreements. And what happens if you don't get a business associate agreement? The OCR considers every single piece of information that you provide to that vendor to be a breach. So that's what happened here. This university failed to have a business associate agreement with its cloud vendor, and it considered it to be a breach of 3,000 individuals. And even though it was the vendor who caused the problem, they had to pay the cost for it. That's what I said. So if you're, and this is another thing. A lot of times vendors will say, I'm not going to sign that. I'm not going to indemnify you. I'm not going to tell you about what my risk analysis says, so forth and so on. If your business associate refuses to sign a business associate agreement, goodbye. You need to find another business associate. There is no excuse for a business associate not signing that contract. Then, are you responsible for your business associate? So as I was saying before, if you have a business associate and you give PHI to that business associate, and that business associate causes a breach, that business associate can now be liable to the OCR. The OCR may find that that business associate was the one who caused the problem and they caused the breach. But getting to that point is a nightmare, because if it's more than 500 people, you now have to send out breach notifications to everybody. All right, that part's not too bad. You have to tell the OCR right away, and the OCR is obligated to come in, investigate you and the business associate. And in the course of investigating you, they might find a totally different problem to penalize you about. So now you have to go through the investigation, you have to hire your lawyers to answer all their investigatory questions. They're annoying. And then your business associate may or may not be the person liable to it. But by the time you get there, you've already expended a lot of money. So although you are not technically responsible for your business associate's actions, you could be bearing a lot of costs if your business associate makes a mistake. So what I'm seeing a lot more of these days is due diligence in regard to your business associates. Different people, depending on your size, do different things. Some people review, the easiest thing is just to see on the OCR website, has your vendor ever had a breach before? And if they did, what did they do to correct that? That's a simple step. Other bigger, larger institutions are starting to send out security questionnaires every year. They want to see that the business associates are actually implementing HIPAA security programs. And some of them even ask for evidence of risk analyses, SOC reports. Health plans even require high trust, which I don't know if you guys know what that is, but it is an expensive certification of security. So that's just a brief snapshot of why I care about business associates first and foremost. Then I just remind you do have to get your privacy notice. I guess in the world of telehealth, that might be a little more complicated, but you do have to have a privacy notice acknowledged by your patients, and that privacy notice would have to be posted on any website that you have. Breach notification, as I was saying before, if there is a breach in that there's an unauthorized use, access, or disclosure of PHI, unless you can demonstrate that there's a low probability of compromise, and for some reason the OCR doesn't give us much guidance on that. If you have a breach, you have to notify all the affected individuals. In addition, you have to tell the OCR. If it's more than 500 people, you have to send out 2 press releases, post it on your website. It is a nightmare. So some examples of breaches that we've seen: a laptop that's not encrypted, and don't have unencrypted laptops. If you get nothing out of this, don't have unencrypted laptops. So if you lose an unencrypted laptop, that would be a breach. An ethical hacker, there's a lot of ethical hackers from all different countries running around. They're always like pinging. Then they get into your system and they say, hire me to fix what I found was wrong. Well, if you don't hire them, that's a breach. I mean, even if you do hire them, it might be a breach, but it's more likely that now, I had an ethical hacker take a bunch of PHI and give it to NBC News. Like, that is a nightmare. And then NBC News went and knocked on these poor people's doors and said, hi, we got your information from this guy in the Ukraine. So disposal without destroying it properly. I have a very funny quick story for you regarding that. I had a client who was beautiful with shredding their PHI. Beautiful. But on Long Island, it's nice here in the summer, you know. So all the staff left the boxes of medical records under their desks. And just coincidentally, they hired a new cleaning company that day. So the cleaning company comes in, sees all these boxes of paper, throws it all in the garbage bag, throws it out in the back. And the guy comes with the truck, throws the bags in the truck, and this is all a true story. He decides to go visit his girlfriend in a neighborhood in Long Island. Hits a bump, bags fall out, nor'easter hits Long Island, and their medical records are scattered all over this community. Yep, get a phone call Monday morning, and the administrator's like, my medical records are scattered all over Great Neck, what am I doing? I'm like, get down there. We had to send out 300 breach notifications of medical records scattered all over this community. Disposal is a big deal. A box containing PHI of 80,000 individuals doing a claims adjustment falls off the back of the truck on Route 80, another true story. So you can see there is a whole host of ways that people can have breaches. Then what they do is, if there's more than 500 people, as if insult to injury, they post all the information on the website for everybody in the world to see. So you have some reputational harm to be worried about as well. Okay, as I said, I'm switching because I don't have much time. De-identification. Just remind you guys that if there is a way to take out enough information from PHI that it is no longer considered to be identifiable, and in those cases you can do whatever you want with that information. You know what's interesting about this? That de-identified information has a whole ton of value. Everybody wants it. It is very, very valuable. So once again, going back to the business associate agreement, when you're negotiating that, you got to really think, do you want your vendor to be able to sell your information, even if it's de-identified? Wouldn't you rather sell your information? Just something to think about. Preemption of state laws. So once again, HIPAA kind of sets the floor. So if there are state laws, and there are state laws, at least in this area, that are more restrictive than HIPAA, the state law wins. So for the big examples in New York, New Jersey, and Connecticut are HIV laws, mental health laws, and substance abuse laws. So where there is a law that is more strict than HIPAA, that law wins. The more strict law wins. Disposal I talked about. Okay, now I go on to the security rule. This is a big myth busters. There is no HIPAA compliant software. Everybody runs around saying, oh, I'm HIPAA compliant, I'm HIPAA compliant. Like, what the hell does that mean? The OCR says the OCR does not endorse, certify, or recommend specific technology or products. So when you're buying a product or technology, you have to evaluate if you think it meets the requirements of HIPAA. It can't, everybody running around saying HIPAA compliant, it doesn't mean anything. The most important thing you can do under the security rule of HIPAA is to conduct a risk analysis. Again, I said that unencrypted laptops is something. This is the other thing. If the OCR ever comes knocking at your door, the first thing they are going to ask for is your risk analysis and then your risk management plan. And I know this is boring, but if you have a business, if you are a provider, if you are a covered entity under HIPAA, or if you are a business associate, you must hire someone, or if you can do it internally, if you can figure it out, to do a risk analysis and keep that risk analysis up to date. A lot of people think the best way to do that is have one every year. That's not technically required, although the OCR would like to see it. So make sure you have a risk analysis and make sure you address any deficiencies in that risk analysis. The OCR will ask for it every single time. Then we have to think about what technical safeguards we have to put on. Obviously, your platforms, your whole world is electronic. So what are the things that you have to think about? Passwords, obviously. I have been speaking about HIPAA since 2003, I think. I have said time and time and time and time again, do not share passwords. Yet probably once a week, I get a phone call from someone who shared a password and has a problem. Really, when I say don't share passwords, don't share passwords. Then there's firewalls to consider, audit trails. I know nobody likes to do them, but you really do need to do them. Encryption, and yet more encryption. That's the best way to protect against a breach. And when I say encryption, I mean encryption at rest, so meaning the device that the information sits on should be encrypted, and in transit, meaning while that information is traveling through the internet, that it is encrypted. Encryption is important. And you know, it's so funny because HIPAA doesn't technically require encryption. There's ways around it, but I would ignore those ways around it and just use encryption. Patching, make sure you're patching, automatic log off, especially if you're using mobile devices, protection of wireless networks, other protections against hacking, all these things to think about. Another thing, so then there's just like not the technology, but the people. The people are always of biggest vulnerability as the technology. So in this instance, they put the penalty $5.5 million, and let me tell you what happened in this story. There was a hospital allowed its physician practice to access its EMR. Commonplace, you guys probably do it. And that physician practice allowed some of its staff members to have access to the hospital's information. The physician practice fires one of those staff members and doesn't tell the hospital. So that person's access to the hospital's EMR is never terminated. And that person shares her password with everybody. They estimated that there was 80,000 people's information exposed as a result of that. For 1 year, she was sharing her password with everybody. I don't think anything bad happened to the information, but she was sharing it. And as a result, the system had to pay $5.5 million. Pure people mistake. Viruses. Okay, here's the third thing I don't want you to forget. Encryption, risk analysis, viruses. The only way to really and truly protect against viruses is to train everybody that they should not be clicking on emails, on like links in emails that are sent by people they don't know. That is how viruses get into your system. And we used to care about hacking and stuff like that, but the biggest concern these days is ransomware. So what happens, you get an email from somebody, you click on the link, in comes ransomware, it encrypts your entire system, you have to pay the person with Bitcoins, and how the hell do you get Bitcoins? And, you know, like really, they have to pay in Bitcoins, in order to get unencrypted. Now, sometimes you can protect against that because you have a backup or what have you, but now you have a potential breach of your entire system. Even if you have a backup, that person's still running around in your system. So over and over again, we at my firm, we do phishing attacks, meaning that we hire somebody to try to get people to click on the links and see how many of them do it. But that is the way that viruses get into your systems. Right. And don't forget about portable devices. Portable devices are awesome. You can work anywhere. I love my portable devices. But they also create a vulnerability. If you have PHI on them, they better be encrypted. They should automatically log out. You should be able to remotely wipe them. There should be password protection, which hopefully will encrypt them. And you need specific policies to address the portable devices. We're all walking around with our iPhones. I know my iPhone has a ton of PHI on it because of the nature of the work I do. And I've lost that iPhone, and thank God I had all these protections, because if you don't, again, a big old breach. In fact, the OCR is so worried about portable devices, the vast majority of settlements with the OCR have involved portable devices, that they came out with new guidance regarding it, where they talk about things that you have to consider in regard to portable devices. It's very hard to manage it. We don't have our heads around portable devices yet, and don't realize how much access they give to PHI, but you really need to consider this as you move forward. This is just another unencrypted phone that resulted in a big penalty. The interesting thing about this case was that somebody lost an unencrypted cell phone. It was determined that that cell phone only had the information of 412 individuals on it, so it wasn't even a breach involving more than 500. Nevertheless, they penalized them $650,000, and the OCR said that was low, that they were just being kind because this particular provider served a very underserved population. $650,000, that's a lot of money to me. This is a question I get from time to time. Are you allowed to use mobile devices to access PHI in the cloud? The OCR says sure. The OCR really doesn't prevent you from doing anything you want to do, particularly in your telehealth world or anywhere. They say, though, if you're going to use your cell phone to access PHI in the cloud, you have to have the safeguards that I was talking about. All those things have to be put in place, and you need to have a BA with your cloud vendor. Don't forget about that. And just quickly, this is what the penalties look like. Willful neglect, you just ignore everybody and you don't correct it. They have to penalize you $50,000 up to 1.5 and all down the road. The interesting thing is I've had people say to me, $1.5 million isn't really all that much money. Well, let me tell you, I had an incident where there's these people called runners, and what these runners like to do is they like to get the information of like workers' comp cases, different no fault, that type of thing, and they sell that information to lawyers, not me, but lawyers and chiropractors and PTs and that type of thing. So this woman at a hospital in New York, for years would write down the information of all the no fault and all those people and sell it to the runners, and then the runners would sell it. She bought a house with as much money she made doing this for 10 years. Anyway, they ultimately caught her and she went to jail. But that aside, there could have been penalties of $1.5 million for her unauthorized access to the information, $1.5 million for a violation of this thing called minimum necessary, $1.5 million for the unauthorized disclosure of that. There could have been 1.5 because the hospital never sent out breach notification letters. So just that rogue employee misbehaving could have cost that hospital $6 million. So 1.5, albeit it's per violation per year, it could really go out. And that story, that woman was doing it for 10 years. So you could have looked at whatever, you can figure it out because I can't remember what numbers I threw out, but like, so the big thing, I guess, the last thing I want to point out is get cyber liability insurance. At the end of the day, really the only way to protect yourselves, and just these are some of the things to think about.